Good afternoon, everybody. Thank you for joining us for today's Lunch and Learn webinar on what business owners need to know. I'm Adam Rossi from the Communication and Outreach Unit at the Workers' Compensation Board. And today we will discuss the basics of the workers' compensation system, including insurance types, coverage requirements, and employers' obligations under the law. We'll also cover who needs coverage and who does not need coverage, how and when to report an injury or illness, including COVID-19, considerations when hiring independent contractors, laborers, and domestic workers, lowering premiums and penalties, and where to go to find assistance. We do ask that you please keep your phone lines muted, as we will be using the Q&A feature to receive your questions today. Again, any questions you have, just enter them right in that Q&A box. And joining me today to take a look and answer some of your questions is Terry Cooper from our Compliance and Litigation Unit. You can enter your questions throughout the presentation, but we will hold all questions till the end. And again, just write them right into the Q&A panel, which should be on the bottom right-hand side of your screen. Terry will answer as many of your questions as she can, but if there are any that we don't get to today, or if you think of something after the session ends, we will be providing you with additional resources at the end of the presentation. So let's go ahead and get started. We'll start with an overview of the Advocate for Business Office, which was created so that business owners could have somewhere to reach out to for assistance with workers' compensation. We assist individual businesses with coverage and compliance. We meet with business owners and government personnel to educate them on the workers' compensation system. We also meet with business associations and employer groups to hear their questions and concerns regarding workers' compensation. These then get reported to the chair of the board, who will discuss whether any systematic changes can be made. What is workers' compensation insurance? It is mandatory insurance that covers on-the-job accidents, injuries, and illnesses. It provides medical treatment for those injuries and illnesses and partial wage replacement. It protects both the employers and the employees by providing medical treatment and coverage, so the employer does not need to hire an attorney for fear of a lawsuit. It also ensures that the employee is being taken care of. New York State also offers mandatory disability benefits insurance. This covers off-the-job accidents, injuries, and illnesses. This type of insurance offers limited wage replacements, and unlike workers' compensation insurance, it does not offer medical benefits. Employees can receive a maximum wage replacement of up to $170 a week for up to 26 weeks. So, who needs coverage and who doesn't need coverages? Quite simply, all businesses with employees need coverage. Who is an employee? Anyone providing any services to a for-profit business can be determined to be an employee of that business if a claim should arise. Also, any compensated individual providing services to a nonprofit can also be determined to be an employee of that nonprofit, with limited exceptions such as clergy or teachers working for an IRS-designated 501c3. Who's not required to carry workers' compensation? Sole proprietors with no employees do not need coverage, since there is nobody else working for them. Partners and partnerships with no employees, or members of LLCs where the only people compensated are those members, do not need workers' compensation insurance. A one- or two-person owned business, for example, a mom and pop shop, does not need coverage as long as each person owns at least one share of stock and they own all the shares between them. Should they add a third shareholder or hire an additional employee, coverage is then required. So now that we've covered what workers' compensation is and who needs it, let's discuss how you obtain it and how much it costs. In order to get workers' compensation insurance, you need to contact a licensed insurance carrier in New York who will provide you with an estimated premium based on the following. First is the classification code. There are different class codes for businesses based on how hazardous the business is. The more hazardous the work, the more expensive the premium will be. Each class code has an assigned rate, which is applied for every $100 of your total payroll. Next, they will consider how safely you operate your business. The safer you operate, the lower the cost of your insurance. If you have several accidents, your insurance costs will continue to rise. You will also get audited 1 to 2 times per year by the insurance carrier. They will look to see if the information you originally provided them was correct, such as the number of employees, the number of subcontractors, etc. They will then determine if your premium was underestimated, overestimated, or if it was spot on. It is imperative that whoever works with the insurance carrier on these audits is very knowledgeable about your business and can answer every question definitively to ensure a true audit. Most importantly, do not miss your audit, and we'll go into details about why later on. Along with the groups we mentioned previously, here are some other groups where some specific coverage issues may arise. Family members. Family members need coverage. If you hire someone in your family to work for you, they need to be covered. Domestic employees, such as nannies, or anyone who works in your home, who work less than 40 hours per week and do not live with you, do not need coverage. If they work more than 40 hours per week, workers' compensation coverage is required. However, Governor Kathy Hochul recently signed an amendment to the workers' compensation law, which includes the extension of New York's disability and paid family leave benefits coverage to eligible domestic workers. Domestic workers who are employed 20 or more hours per week by the same employer, including sitters or companions and live-in maids, are now considered covered employees for the purposes of disability benefits and paid family leave. Independent contractors can be more confusing than other groups. So let's take a look at a scenario to further explain how the board views independent contractors for workers' compensation purposes. You'll see here a scenario on your screen, and what I'm going to do is I'm going to put up a poll, and we want to get your thoughts on what you think Jen should do about obtaining workers' compensation insurance for her tutoring services. So Jen would like to start her own SAT tutoring business. Her model is to hire independent contractors who will offer all tutoring services for students. The parents will contact Jen to match their child with a tutor and pay her for the tutor. In turn, Jen will pay the tutors for their services. So in this scenario, is Jen required to provide workers' compensation insurance for her tutors who are being treated as independent contractors? Again, we have the poll up. If you just want to give us your answer, we'll take a minute to collect those answers. We got them coming in right now. Looks like we have a few no's, a bunch of yeses. It looks like the majority here, we got, the majority of you are saying that Jen should have workers' compensation insurance for her employees. And for those of you who have responded yes, I will happily tell you that you are correct. So for those of you who said no and are wondering why would Jen need workers' compensation insurance, let's take a look at the details. Jen is offering tutoring services, and she is hiring employees to provide these tutoring services. The parents are paying Jen, but Jen is paying the tutors for the services requested by the parents. So for workers' compensation purposes, there is nothing independent about the relationship between Jen and the tutors because they are providing the actual model for her business for her. An example of an instance when Jen would be an independent contractor would be if Jen had her own office and she had hired someone to fix the air conditioning unit. That person would be considered an independent contractor and would not require workers' compensation coverage. So thank you all for participating in that polling there, and good job to those of you who answered yes. All right, moving on. Here are some examples of what the board's administrative law judges look at when determining whether or not someone is an independent contractor. The first thing they look at is direction and control. Does the hiring business control the time and manner in which the work is to be done? So for example, do they control when to come to work, what work they need to do? They will also look to see if the business being hired has their own Federal Employer Identification Number, or FEIN, from the IRS, or if the business has filed tax returns to establish that they truly own their own business. A full list of criteria that goes into determining whether a business or individual should be considered an independent contractor can be found on the employer section of the board's website at wcb.ny.gov. If you're in the construction industry, you should be aware of the Construction Industry Fair Play Act, which is overseen by the New York State Department of Labor. Under this act, workers are presumed to be an employee unless they can prove they have their own business. You can learn more by visiting the Department of Labor's website at labor.ny.gov and searching for the Construction Industry Fair Play Act. If you're a general contractor, under the law, you are liable for the workers' compensation claims of all uninsured subcontractors. Here's what you need to be aware of in these instances. If you hire a subcontractor, have them provide you with a certificate of workers' compensation insurance that you can provide to your insurance carrier upon your audit. If they do not have workers' compensation coverage, and you were to become injured they were to become injured while working for you, your insurer would be responsible to cover their claim. And in turn, this will increase your premium because the insurer had to cover the subcontractor. However, if the subcontractor has workers' compensation insurance and you have that proof of insurance to provide to your insurer, they cannot charge you in the event of an injury. The board suggests that you have subcontractors add you as a certificate holder to their workers' compensation policy at no cost to ensure that the subcontractor is making their monthly workers' compensation payments and therefore not holding you liable in the event of an injury. If you are required to have workers' compensation insurance and you don't, the board will find out. The board receives notifications regarding employer payrolls and other information that shows who does and does not have coverage. In the instance you are caught not carrying coverage, a noncompliance penalty will be assessed. The penalty is up to $2,000 for every 10 days you are found to be out of compliance, or up to $72,000 a year. If you have up to 5 employees, it is a misdemeanor subject to an additional penalty up to $5,000. If you have more than 5 employees, it is a Class E felony subject to an additional penalty up to $50,000 and a maximum of 1 1/3 to 4 years in prison. The board also looks for misclassification, which is treated the same as being uninsured. Misclassification is when an employer lies about their information in order to obtain a lower premium. So for example, if you're telling the insurer that all your employees are doing clerical work, when in fact you have a carpentry business and they're all carpenters, the board treats that as a very egregious penalty. It is not tolerated. There's also something called the Debarment law. If you have any penalty with the board, you are barred from bidding on or being awarded any public works contract or subcontract with New York State, any municipal corporation or public body for 1 year for each violation. There's also a ban of 5 years for each felony conviction. So this is why it's very important that you never lapse on your workers' compensation insurance. Sometimes employers will have a dispute with the insurer regarding the cost of the premium and refuse to pay. The board will view this as lapsing coverage, so you should always pay the premium, even if you disagree with it. You can always ask to have the board review the estimate. If it's reviewed and the board deems you are correct, you will receive the appropriate funds back. So please pay your premium even if you are disputing it. We had talked about earlier about missing audits, and we say you should never miss an audit. If you miss an audit, the insurer will issue an estimated audit in lieu of meeting with you. Typically, this estimated audit will increase the premium from prior years, and sometimes employers will refuse to pay this. The board also views this as lapsing coverage, and it will place you on the debarment list. Should you receive a penalty from the board, there is an appeal process, so please don't stick your head in the sand. We will find you. If you have questions or concerns regarding coverage issues, please contact the Advocate for Business office. In instances where you lapse coverage, you can let the board know about the lapse and attach appropriate documentation that shows exactly how much you are paying in workers' compensation coverage. The board can then reduce the penalty based on that. So for example, if an individual hires a nanny and they're unaware that they need workers' compensation coverage for that nanny, the board will send them a letter notifying them that the individual is that they are being penalized. However, the individual can then obtain the coverage, send the board a letter with an explanation that they were unaware that they needed the coverage, along with documentation showing that they now have coverage for the nanny. The board can then use that information to decrease the penalty accordingly. The best way to control the cost of your premium are as follows. Make sure you're in the right classification code. You can always check with your insurer if you are unsure of your code. If you believe you are in the wrong class code but the insurer disagrees, you may contact the New York Compensation Insurance Rating Board, or NYCIRB. They create the class code, so they can look at your information and direct the insurer as to which class code you should be in. Follow your claims. Work with the insurer and the employee regularly. Try and bring the employee back as soon as possible, even if it's only on light duty. The quicker they can get back to work, the better it is for them and for you. And finally, make sure you are operating safely. One way to ensure that you're operating safely is to hire a labor management safety committee. The board suggests picking an equal number of members from labor and management to meet regularly with an agenda and regularly rotate the chair of the committee. Once the committee is established, thoroughly walk the property, visit the workplace, review the equipment, sites, and procedures. Establish safe procedures and trainings to ensure that they are being done properly. Most accidents occur when shortcuts are taken, and oftentimes management is unaware of these shortcuts. That's why it's important for both the laborers and management to work together and communicate to ensure things are being done safely and correctly. The Department of Labor offers a workplace safety prevention incentive program, which is commonly called Code Rule 60. This is when a business voluntarily establishes a safety, drug and alcohol prevention, or return to work program. With this program, businesses can save up to 10% on their workers' compensation insurance the first year and up to 6% in their second and third years. More information on Code Rule 60 can be found at the Department of Labor's website at labor.ny.gov/WSLPIP.html. You can also see that link right there on your screen. The Department of Labor also provides an on-site consultation program at no cost. They will walk the property and help mitigate safety risks. Please note, they will not be looking for any violations, only ways to help you make the workplace safer. For more information, please call 518-457-2238. So, your responsibilities as the employer are as follows. Obtain the required insurance. Your insurer will provide a poster highlighting the requirements for your insurance. Please display that poster in a place visible to all employees. Report all claims in a timely manner. Section 120 of the New York State Workers' Compensation Law states that an employee cannot be discriminated against for filing a workers' compensation claim. You cannot take punitive action against a worker for filing a claim. Employees can only be terminated for valid business reasons, including misconduct, insubordination, lack of work or economic reasons, a lengthy absence from work, inability to perform the job, or poor performance. However, the board encourages all employers not to terminate employees unless absolutely necessary. Lastly, all employees are eligible regardless of their citizenship and/or their immigration status. So now we'd like to take some time to discuss New York's paid family leave benefit with you. New York State paid family leave provides you with a structure to help your employees care for their families in times of need. Paid leave has been shown to increase workplace morale and employee retention. Fully funded by employee payroll contributions, New York State paid family leave provides job-protected, paid time off to employees who need time away from work to bond with a newly born, adopted, or fostered child, care for a family member with a serious health condition, or assist loved ones when a family member is deployed abroad on active military service. Employees can also use paid family leave to support themselves or a minor dependent child in the event of a COVID-19 quarantine. Paid family leave provides both parents time to bond with a new child within the first 12 months of the birth, adoption, or foster placement of the child. Parents who work for different employers can take paid family leave at the same time to bond with the same child. Parents who work for the same employer can take it at the same time unless their employer prohibits it. In that case, they can take leave separately over the first 12 months following the child's birth, adoption, or foster placement. It's important to note that expectant mothers cannot take paid family leave for their own pregnancy. They can take it after the baby is born because paid family leave is used to care for someone else, so they'd be caring for the baby. A parent may be able to take paid family leave before the actual adoption or placement of a child if an absence from work is required for the adoption or foster placement to be finalized. Paid family leave is also available to employees to care for a spouse, domestic partner, child or stepchild, sibling, whether biological, adopted, half, or step, parent, parent-in-law, step-parent, grandparent, or a grandchild who has a serious health condition. We want to note that coverage for siblings will not begin until 2023. Please check with your insurance carrier for details on when this goes into effect for your policy. Currently, siblings are not qualified to care for. And to clarify, a domestic partner is defined broadly under the paid family leave law. It includes people who are not related by blood in a manner that would bar marriage in New York State, and they are dependent on one another for support. So, for example, an employee may be able to prove that they are in a domestic partnership by showing that they own property together or they have children in common. A legal relationship is not necessary. And it does not matter if these family members live outside of New York State or even outside the country. Employees can take paid family leave to care for their family member as long as they are within close and continuing proximity. So in other words, present at the same location as the family member they're caring for during a majority of the paid family leave period. This may include necessary physical care, emotional support, visitation, assistance in treatment, transportation, arranging for a change in care, assistance with essential daily living matters, and personal attendance service. In order to take this type of leave, the employee's family member must have a serious health condition. A serious health condition is defined as an illness, injury, or condition that requires either inpatient care in a hospital, hospice, or residential health facility, or continuing treatment or supervision by a healthcare provider. And we do want to note a COVID-19 diagnosis may qualify as a serious health condition. Third type of leave is for assisting during a military deployment. Paid family leave benefits are available when employees have a spouse, domestic partner, child, or parent on active service abroad, or who has been notified of an impending call or order of active service abroad, and family assistance is needed. Reasons for paid family leave for an active service deployment are the same as the military provisions of the Federal Family Medical Leave Act, or FMLA. They cover the employee's spouse, domestic partner, child, or parent. There are a number of instances where paid family leave will help, which are shown here on your screen. There are also two uses of paid family leave related to COVID-19, which we'll cover in a few minutes. Most private employers with one or more employees in New York State are required to have paid family leave insurance in place. Generally, this coverage is added to your existing disability benefits policy. The insurance policy provides payment of the paid family leave benefit to your employees. Public employers may choose to offer paid family leave to their employees, and public employers with union representative or union represented employees may offer paid family leave if it is negotiated through a collective bargaining agreement. If you are a sole proprietor or a self-employed individual, you may voluntarily opt in for paid family leave coverage. If you opt in within the first 26 weeks of starting your business, there is no waiting period to receive paid family leave coverage. If you opt in after 26 weeks, there is a 2-year waiting period. Eligible employees can take up to 12 weeks of paid family leave and receive 67% of their average weekly wage, capped at 67% of the New York State average weekly wage. Generally, an employee's average weekly wage is the average of their last 8 weeks of pay prior to starting paid family leave. The New York State average weekly wage is updated annually and published on the New York State Department of Labor's website at dol.ny.gov. As we approach 2023, the New York State average weekly wage will be $1,688.19. It's important to note that employees can take this paid time off all at once or intermittently, but it must always be in full-day increments. Paid family leave is fully funded through employee contributions. Employers must procure the coverage and may deduct the cost from the employee's paychecks. Please note, employers cannot do this for workers' compensation insurance. This is for paid family leave only. Since paid family leave is employee-funded insurance, the employee pays the cost of the insurance. Contribution rate is reviewed annually and is subject to change by the New York State Department of Financial Services. For 2022, the payroll contribution is 0.511% of an employee's gross wages each pay period, and the maximum contribution is $423.71. To do the 2023 contributions, just go to that paidfamilyleave.ny.gov website, and we have an update for 2023 section. You can check there. If an employee earns less than the statewide average weekly wage, they will contribute less than the annual cap consistent with their actual wages. Again, please visit paidfamilyleave.ny.gov/cost to learn more about cost information. There's also a deduction calculator that will help employees determine how much of their weekly wages will be deducted for paid family leave. So who's eligible for paid family leave? Covered employees are eligible to take paid family leave for a qualifying event once they have met the minimum requirements. For full-time employees, employees who work a regular schedule of 20 or more hours per week are eligible after 26 consecutive weeks of employment with their employer. Part-time employees who are regular schedule of less than 20 hours per week are eligible after working for their employer for 175 days, which do not need to be consecutive. And again, citizenship and/or immigration status is not a factor in employee eligibility. Paid family leave coverage is not optional for most employees. Some part-time or seasonal employees may qualify for a waiver to opt out of the coverage. Employees can only waive coverage if they regularly work fewer than 20 hours per week and won't work 175 days in a year, or if they regularly work 20 or more hours per week but won't be in employment for 26 consecutive weeks. If an employee meets the criteria for waiving coverage, you must provide them with a waiver form, which is available at paidfamilyleave.ny.gov/PFL-waiver-form. If an employee chooses to waive coverage, they will not make contributions and will not be eligible for paid family leave benefits, and you must keep a copy of the waiver on file. If an employee's schedule changes such that they no longer qualify for a waiver, that waiver will automatically be revoked within 8 weeks of the schedule change. An employee can also voluntarily revoke a waiver at any time. If an employee's waiver is revoked, their employer will begin taking paid family leave contributions and collect any retroactive amounts due. Keep in mind, however, that any amounts collected in excess of the paid family leave premium charged by your carrier must be promptly returned to the employees. Your responsibilities as an employer regarding paid family leave are as follows. Obtain paid family leave coverage and pay the premiums with funds collected from employee payroll deductions. Provide information about paid family leave to employees. Let them know what it is and how they can use it. Should an employee request paid family leave, you will need to provide wage information to the insurer. Visit the employer section at paidfamilyleave.ny.gov for more details. Now let's discuss COVID-19 and what you need to be aware of as an employer and how it pertains to paid family leave. If a worker notifies you that they have tested positive for COVID-19 and they believe they contracted it at work, you must report it to your insurer, who will file a claim with the board. You should also be aware of COVID-19 quarantine leave. This provides workers with job protection and financial compensation when they or their minor dependent child are subject to a mandatory or precautionary order of quarantine or isolation. Most employees will receive financial compensation by using a combination of benefits, which may include employer-provided paid sick leave, depending on the size of the employer, paid family leave, and disability benefits. Visit paidfamilyleave.ny.gov/COVID-19 for full details. Your role in implementing the COVID-19 quarantine leave, whether you're self-insured or providing these benefits through an insurance carrier, is largely the same as it has been for New York State paid family leave overall. There are forms for COVID-19 quarantine leave, which are available at paidfamilyleave.ny.gov/forms. And again, please visit paidfamilyleave.ny.gov/COVID-19 for full details on this, including guidance for employers. For most employers with 10 or fewer employees and a business net annual income of less than $1 million, employees can use a combination of paid family leave and disability benefits. After receiving their full paid family leave benefit, up to $840.70 weekly, employees will receive disability benefits to match their full wages up to a maximum weekly disability benefit of $2,043.92 for a total $2,884.62 per week. There is no waiting period for either benefit. Employees will have job protection for the duration of the quarantine. For most employers with 11 to 99 employees and smaller employers with 1 to 10 employees with a business net annual income greater than $1 million, you are required to provide at least 5 days of COVID-19 paid sick leave. Eligible employees can then use paid family leave. After receiving their full paid family leave benefit, again up to $840.70 weekly, employees will receive disability benefits to match their full wages up to a maximum weekly disability benefit of $2,043.92 for a total of $2,884.62 per week. Again, there is no waiting period for either benefit, and employees will have job protection for the duration of the quarantine. Lastly, for most employers with 100 or more employees, as well as all public employers. You are required to provide at least 14 days of COVID-19 paid sick leave for a COVID-19 related quarantine, which should cover the period of a mandatory or precautionary order of quarantine or isolation. And as with the other two, employees will have job protection for the duration of the quarantine. For more information on paid family leave and taking paid family leave for COVID-19 quarantine or isolation, please visit paidfamilyleave.ny.gov, or you can call our helpline at 844-337-6303. Before we get to your questions today, we do want to update you on our onboard business information system, which is now fully phased in. Some of you on the call today may be familiar with this system. This is replacing our multiple paper-based claim system, such as eCase, with a single web-based platform. With a focus on improving the entire workers' compensation experience for all stakeholders, the new system offers exciting elements, including real-time claim data, new electronic self-service features for interacting with the board, easy accessibility allowing you to verify the receipt of documentation, understand the status of your claim, check on pending documentation requests, and a reduction in the amount of overall paper forms to improve system responsiveness to all employee needs. Stay informed, and for more information, keep an eye on our website at wcb.ny.gov/onboard. You can also stay informed on all workers' compensation news by subscribing to get board notifications straight to your inbox at wcb.ny.gov/notify. You can also visit wcb.ny.gov and select Get WCB Notifications on the bottom of the homepage, and you get to choose the topics you'd like to receive updates to. You can also follow the board on Twitter, Facebook, Instagram, and YouTube for board news, project updates, trainings, and more. And as part of that more, if you go to our YouTube page, you will see previously recorded versions of this actual webinar. If you have questions or concerns, please do not hesitate to contact our office at 518-486-3331, or you can email advocatebusiness@wcb.ny.gov. You can also find information on our website by searching for Advocate for Business at wcb.ny.gov, and I will leave this slide up here for you guys to write down while we now take your questions. Again, if you have any questions, feel free to insert them in the Q&A panel. We have Terry Cooper from our Compliance and Litigation Unit here to answer any questions that have already come in or any questions that are going to come in. We're going to take a brief period of silence to let Terry review those, and we will be back with you shortly. Thank you. All right, so we have a number of questions on paid family leave. We actually, if you have PFL-specific questions, if you want to either call the paid family leave helpline, or if you go to our paid family leave page, let me go back here. We have experts on paid family leave who can answer questions you may have as regards to either whether it's eligibility or the premium cost, the disability information that we gave. Give that helpline a call, check out that website. They should be able to answer any paid family leave specific questions you may have.
All right, good afternoon, everyone. I'm just going to kind of start in the order that the questions were received since the start of the webinar, so that way I can keep track of what I answered and what I didn't. I may be giving some referrals to some email boxes that could actually help you with more specific questions, and if you have follow-up questions, you could place them there. One of the first questions that we got, and this is actually a really great question, we get this a lot in our compliance unit, is it's an out-of-state employer who has a remote worker who is performing services and residing in New York State. So what are the requirements for that? And especially since you probably have insurance in your own state, how does it work with that insurance policy? So first off, your existing policy may well work fine to cover that New York State employee if your carrier is licensed to write coverage in New York and that you can endorse New York on item 3A of your policy. that is what our requirement is. The 3A coverage for New York is the requirement once somebody starts performing services within our boundaries. So if your existing carrier can provide you that endorsement, then you can use your existing policy. If your existing carrier does not write coverage here in New York, then you would be required to purchase a separate policy or, move your whole book of insurance over to a different carrier that would cover all states. That pretty much covers that question. The next question on there is a nanny that is not living at an employer's home began to work less than 40 hours per week. The employer was not required to get WC insurance. Later, the nanny and the employer modified the nanny schedule, and the nanny now works 40 hours per week. The employer was required to get coverage instant the first week that they reached the 40 hours. Keeping in mind that the 20-hour rule applies to DB, so DB needed to be in place if it was over 20 hours, even prior to the 40-hour requirement. So the minute the 40 hours was reached, that domestic household becomes a covered employer for workers' comp, and the policy is required. There is not really a grace period. That was part of this question. When you become subject, hitting that 40 hours, then the non-compliance starts from the date you hit the 40.
I see a question here asking about employee webinars, such as this one for employees. We do offer a webinar for employees. It's much similar to this one. We just give the basics of the workers' compensation system. If you go to our website, wcb.ny.gov/webinars, you'll see a list of those dates. Just like this session, we host it monthly. And if you want to get up and register for some of those, you are certainly more than welcome to.
The next question is kind of PFL related, and this one is easily answered, so I'll answer it for you now. It does pertain to a policy drafting, but I think the real question is, how does it work if you need to take care of somebody and it's not consecutive days, it's intermittent, like you need to bring them to a doctor appointment, or you're sharing the load of caring for that individual with another person who's, taking shifts. Paid family leave can be taken intermittently, but it must be taken in full days. You can't take 2 hours off. You would have to take your entire work shift off. I'm not exactly clear on that, but the question, but if you live in the United States and you have a family member, who lives out of the country who now needs you to come and care for them, that would be covered under paid family leave. You have to be in contact with the person providing them on-site care in order to be eligible to use that family member as a reason for paid family leave. The next question is, can an injured employee be terminated for violating a safety policy or procedure that caused their injury? That is really a legal question that I don't feel comfortable answering in this forum. This would probably be litigated, honestly, and I would touch base with the New York State Department of Labor in regards to termination requirements, because it would actually fall under something that they would oversee. Will COVID still be covered past the end of this year? It's not really clear whether this question means the leave that we are allowed or have to provide to the employees, or if you mean COVID and PFL. So if you did want to, send that question with some clarifying down on the bottom, we can review it later as we get down through.
I see a question asking what the name of the YouTube video for this recording would be. I believe it's called What Business Owners Need to Know. If you go to our YouTube page, again, it's youtube.com/New York State Workers' Compensation Board, I think. Hold on, let me just confirm that here. Yep, youtube.com/New York State Workers' Compensation Board. You'll see a list of all the videos we have, and you'll find the What Business Owners Need to Know series.
All right, the next question. PFL is only required for private employers, correct? That is correct. As a public employer, which would include, an employee, a municipality, a school district, a state-funded college, a New York State agency, even a county agency or a village department, they are not required to carry either disability or paid family leave. Paid family is actually like a rider on a disability policy mostly. The requirement is not there. They can, however, negotiate with the union representatives to provide those benefits to a certain unit, but it has to be a union negotiated contract. Part of that reasoning is the deductions, you know, the employees have to agree to those deductions, and another part of why the disability has never been part of a government employee's benefit is that we are provided many more days of sick leave and vacation time and personal days that the private industry is not provided. So it's believed that those days would be used in place of like a disability benefits or paid family leave. So that kind of covers the next one. Why doesn't New York State require all employers to cover their employees under PFL? I pretty much think I covered it there. Copy of the presentation was answered. The requirements for the paid family leave waiver, again, if you just want to go to that paid family leave website, that is right on the screen. It very much details what the waiver requirements are, and there's actually a PDF waiver right there that you would have access to if you went to the website. If you have a TPA for WC, will you now be able to get WCB notices electronically? If you're talking about the onboard system, I'm not aware of them like automating notices out by email, but more information on the onboard system can be found, you know, on the help when you access onboard. The next question, for a small municipality with less than 60 employees, we are required to offer 14 days of paid leave for a confirmed case of COVID. Is there a limit to how many instances a year this is required, or is it unlimited? Also, is there any differentiation for instances between vaccinated or unvaccinated? I can definitely tell you there is no difference between vaccinated or unvaccinated employees. I am actually uncertain on how many times you have to provide the 14 days for the confirmed case of COVID. So it would be good if you directed that to the email box or to the website for a correct answer. Subcontractor is the sole proprietor and is not required to hold workers' comp and is injured on the job. Is the contractor's WC carrier responsible? If so, does the injured file as a C3 with WCB as the sub would not know who the carrier is? So it's it's a complicated question. So if I'm a general contractor and I hire a subcontractor, for instance, who is a sole proprietor and has no employees of his own, is technically not required to carry coverage. That subcontractor could file a C3 with the board and file a claim against the general contractor. It would then go through a series of litigation to determine, was the subcontractor truly an independent contractor at the time of injury, or was there enough direction and control to establish that there was an employer-employee relationship between the hiring party and the sub? You know, if it was found that they indeed are an independent business, that there is no employer-employee relationship, and that the criteria is very stringent to uphold that, then the claim would actually be disallowed. It's not automatically paid. If it was found there was an employer-employee relationship, then the general contractor's carrier would be liable to pay that claim. And if for some reason that general contractor was uninsured because they had no direct employees and didn't purchase a policy, then they would be personally liable to pay for that claim on uninsured injury. Is the employee count requirement for COVID quarantine employees in the state of New York or anywhere? My understanding is that is in the state of New York for our laws, but there is some federal laws that cover the number of employees, so it might be nationwide when it comes to those. You would really need to look that up on a federal website in regards to those COVID requirements. I am seeing quite a few other kind of COVID questions on here. did you have a specific place you wanted those referred
Yeah,
to?
anything COVID-19 related. If it pertains to the COVID-19 with paid family leave, again, we suggest you go to the paid family leave website, and then they have a COVID-19 specific designated site. We also, this is mostly PFL, we also have a COVID-19 website page on our website. If you go to wcb.ny.gov/COVID-19, you can find more information about needing to file workers' compensation claims for COVID-19. We also host a monthly webinar regarding COVID-19 in the workplace, so you may be interested in signing up for those. Again, go to our webinar website, and you can sign up for one of those. And also, I do see a lot of these questions are pertaining to paid family leave and COVID-19 leave. We actually have a paid family leave webinar for employers coming up on October 20th. And we will go over some of that stuff, and we will have one of our subject matter experts on hand to answer any questions regarding that. So there's registration is not required for that. It is a free session. If you go to paidfamilyleave.ny.gov, you'll see the webinar section there, and it is right up on there. You can add it to your calendar. Again, that is going to be on October 20th at noon, so we highly recommend you join that session as well.
All right, and it looks like the last question that would be pertinent to things that I can answer is, how is a policy managed when there is a merger and a new company takes over the old company with no change in employees? Does the policy just use new company? So I kind of think what the question is asking is, there's an existing business that has workers' comp insurance and employees, and they actually get bought out or merged out, and a new company takes those employees over. Do you need a new policy, or does your existing policy work? So the way that it works for us is policies and the need for coverage is federal employer identification number based. So whatever federal employer identification number is reporting the payroll, that is the entity which needs to have the policy. So you can take an existing policy and endorse a new federal ID number, if that's the case. If you're retaining the same federal ID number under which the employees are going to be working, then you don't need to do anything at all. So just keep in mind that everything is federal ID number based, so whatever your payroll is under, that's what your policy needs to be under in order for everything to link up appropriately.
All right, thank you, Terry. That is a good question to wrap up on. Thank you all for joining us. Thank you again, Terry, for taking the time to answer our questions today. And again, if one of your questions was not answered or if you think of something later, feel free to reach out to that helpline or that email address you see on your screen, and we will take a look and get you an answer as soon as we can. Also, just a reminder, as part of the Advocate for Business series, this webinar will continue to be offered in the coming months. So if you need a refresher at any point, or if any of your colleagues couldn't join today, there will be other opportunities. You can find a list of webinar dates for this series and a variety of other topics as well on the board's website. Again, that is wcb.ny.gov, and then we go to our webinars page. Our next presentation for business owners will be on Wednesday, November 2nd. And lastly, again, I just want to remind you, you can also sign up to receive workers' compensation news, including information on future webinars straight to your inbox. To sign up, visit the Workers' Compensation Board website, scroll down to the bottom of the homepage, and select Get WCB Notifications. We do also distribute information via social media, so again, please be sure to follow the board on Facebook, Twitter, Instagram, and YouTube. Thank you again for joining us today. Please enjoy the rest of your afternoon.